Good evening, everybody, and welcome to our presentation this evening called Using Trust to Keep Your Assets Private. I'd like to welcome everybody who is coming in today, who has made the time to come and find out a little bit more about asset protection and property ownership and how we can preserve and protect our wealth for our families and generations to come. Okay, and this presentation is brought to you by the First Republic Register Foundation, and I'll tell you a little bit more about the organization behind the trust creation. So, the First Republic Register Foundation was founded on the 12th of December 2013. The FRRf, as it's shortened down to, is an international platform for all people to file and record titles to their corpus, property, and private conveyance. And it's approved by the International Courts of Justice and the ICC, which is the International Criminal Court as well. So mainly when it comes to law and property and all things that we do, it's all down to contract, and it's all down to having recorded files of events that happen. So when you register a birth, it's recorded and it's public and people can find that information. When you sell a property, there are deeds and titles that are changed over and those are public property. So we always have to have a registrar, and this is what the FFR is. The FRRf is a registrar. Okay. So the benefits of trusts. So some of the benefits of having a trust and the use of trust is really to hold your assets. Now, the benefits of that is you can have personal privacy. So some people do large transactions. They buy property, they buy businesses, they buy houses. And sometimes they might not want that information out in the public. They may not want to disclose that they've bought that property or land. Benefits of trust, it avoids probate. So you can sort out all the things you'd like to happen with your estate when you die with a trust. So your minutes and your provisions would allow you to do what you like, as you say, with your estate, rather than having to go through solicitors and whatnot. Protects your assets. Now, one thing about trust is that the ownership of your assets goes into the trust, so you're no longer liable or you're no longer the owner. So it protects your assets. It's good for preserving inheritance as well. So a lot of people, especially here in the UK, when it comes to inheritance tax, it's quite a big levy. It's about 40%, I believe, when people pass on their estates. And especially for people who are coming into or have lived in England, maybe second, third generation, maybe their parents came from Caribbean, Africa, or other countries. And so the inheritance situation is quite new to a lot of people. So trusts have been used for quite a while to preserve taxation and inheritance. And it can help with financial wellness. So, I mean, these are the usual reasons why people set up trusts. And different trusts do different things, but the main part of having a trust is to protect your assets and protect your family and future generations to come. So the history of trust. So in Europe and America, the wealthy have been using trusts for centuries to protect their assets and personal property. Trusts date back to the time of Julius Caesar. So we're looking at a very, very, very long time. Families of nobility and the wealthy use trusts to protect their wealth through their families. So people could basically create trusts and entrust the assets to their sons, their grandchildren, and their grandchildren. And trust creates privacy when buying or owning property. Now, what a lot of people don't know is that Walt Disney bought where he built Disneyland in America, he bought that through a land trust. So he bought that land privately because he didn't want to disclose that he was the owner or buying that particular piece of land. So different people use trust for different things. And the trust setup does date back a very, very long time. We're going back to 12th century. And these are legal instruments and vehicles that allow people to protect their assets. So as J.D. Rockefeller says, control everything and own nothing, which is a really important concept in wealth and in managing assets. So why more people don't use trust? Well, one of the things that people tend to think about trust is that it's really complex and it's something very, very expensive, and also a lot of people don't realize the value of what they have as well. Some people think they need to have millions and, mansions and all sorts of luxury items and stuff to hold a trust. But that's not the case. And more people are, putting their assets in trust vehicles and different types of vehicles that aren't necessarily used by the day-to-day person, let's say. So only 1% of the population utilize and understand trusts. And that's pretty much the fact. Like, there's only a small proportion of people who actually understand and know how to use these vehicles for the betterment of themselves, whether it's avoiding taxation, whether it's keeping privacy and whatnot. There is literally 1% of the people that do this. But it is very cost effective and easy to set up. It's based on law, really, and law's written word. So trusts are just a series of provisions, and we'll go into it a bit more about how we set up a trust, because I'm going to show you guys how these trusts are created. So which property goes into a trust? So pretty much anything with value. So it could be cars, your home, cash in a bank, businesses, stocks, shares, jewelry, and even digital assets like Bitcoin. So anything that's got value, really. Some people own digital assets that may be online, or again, just anything that has value that you want to pass down to your next generation. So this is the structure of a standard trust. So you always have, in a standard trust, so there's different types of trusts, there's many types of trusts. But for a standard trust, you would have your grantor, and then grantor or settlor. Then you would have a trustee that plays another position, and a beneficiary. So, for example, your grantor could be the person who has the assets, who wants to now entrust them to the trustee. And the grantor can be the beneficiary as well. So, the beneficiaries can include the grantor and other people. So, for example, I want to set up a trust. I become the grantor. I get a trustee. I appoint a trustee. And really the beneficiary acts upon my provisions, what I say. So the key components of a trust or a standard trust is the grantor settlor, the party who transfers a title or real property to another buyer, grants a deed. So they say, and this is a legal process or a legal procedure that's done by deed. So everything in sort of the European way of law has to be written, has to be recorded, has to be by deed. Then you have a trustee who owns a legal title of the real property or the personal property subject to the beneficiary. So whatever they hold is subject or on behalf of the beneficiaries. And then the beneficiaries hold the equitable. So this is all about equity. The equitable title and retain the power of direction over the trust unless they choose to delegate that power of direction to another individual or entity. Okay, so those are the three components, and pretty much every single trust works this way. The differences will be the provisions, what the trust does, what it doesn't do, what it allows you to do, but in essence, most standard trusts work this way. Okay? But not all trust structures are the same. They're not the same. There's many, many different trusts. You've got express trust, you've got bare trust. There's like probably 50 or 60 different types of trust or more that you can choose from. But we're going to just distinguish the two main types of trust that fit into statutory or non-statutory. It's important to know this distinction when it comes to creating a trust. So we'll just look at the key differences between a statutory trust and a non-statutory trust. So statutory trusts are legalized what we call legalized dictatorship. So there's one central person at the top who or Congress. So statutory laws fall under the legislation of each jurisdiction, which means they'll be subject to taxation and administration, and they must be administered or registered with an administrative agency like the IRS and HR Revenue and Customs. Okay. So non-statutory trusts, aka common law trusts, they're established by contracts known as a fidelity ceremony. And they're based on the common law principia and pure trust provisions. They're not subject to taxation nor local administration, and they do not need to be registered with any local authority. Only public records is necessary. So it's important for all contracts to be recorded by certificate and by paper, but also publicly as well, for it to be classed as legal. So the thing about law, there's so many bodies of law, and trust contracts fall into common law and equity law. Now, as you can see, we have administrative law, private law, public law, international law, constitutional law, treaty law, federal law, state law, probate, family law, the list goes on. But all these law in any system, or is part of the system, is created to recognize rights, duties, or obligations, and provides a forum which to seek a remedy in the event that those rights, duties, and obligations are breached. So at the basic level of common law is about human rights based on, somebody breaks somebody's car or breaks an item of somebody, that they could go to a court and they could dispute it and have it resolved by the jury, who they say this is a penalty. You've got family law that's a little bit different, but the whole point of law is to uphold the rights and the duties and obligations of people, which is to make things fair, which is there to make things fair and there to make things just for everybody. But there's so many bodies of law, and when it comes to trust, we use a trust called the common law pure trust, which falls under the common law jurisdiction. So what is a common law pure trust? So common law pure trust, which is shortened for CLPT, is the purest vehicle for land and asset protection. The jurisdiction of a CLPT is universally domiciled. So that means it's not subject or not in or created in a specific domicile area. So it's basically floating. It's a floating entity. It exists as an international global entity, not subject to any particular jurisdiction or legislative legal boundaries. The CLPT protects one's land from state, federal government intervention in principle. So this is what the trust is. So this trust, the CLTP's provision was created in the 12th century between King Henry II and Lord Bower. And this trust between Lord Bower, their trust is still intact today. And this is the family, so the Bower family, so it's the Bower Rothschild family, who were very instrumental in the creation of the banking system. And one of their family members, so Lord Grantham Taylor Hughes, who is also one of the endorsers or founders, managing partners of the FFR, was the person who provided the provisions for the trust that we use. So he was a former trust lawyer, and the provisions that come with the trust and the trust creation and execution process was all from this foundation, which Lord Grantham Taylor Hughes provided. So this trust has been used for hundreds of years, and the provisions have been revised, I believe, about 104 times. And the newest availability of keeping the assets pure and the assets safe is through the CLPT. And this is a trust that many, many, many of the elites and the wealthy use in order to literally keep their businesses and their taxation and all their assets private. So the structure of a CLPT is a little bit different to the normal structure because you don't have one central person at the top. So you have more of a square structure. So there's 4 players in this trust setup. So you have the creator, then you have the exchanger grantor, you would have your first trustee, and then an agent, or what we call managing director. But for sort of written and legal purposes, it's called agent. So I'm just going to go through the structure of the CLPT. So the creator, so this participant creates the pure trust certificate and is one of the 2 participants in the pure trust fidelity ceremony. The other participant is the exchange grantor. The creator's purpose is to create the trust document and appoint the first trustee, giving him the consideration for the trust fidelity ceremony. The trustee now holds the first asset of the trust as the fiduciary. So that's the role of the creator. They create the pure trust certificates, which are the documentation that's required to certify and intact the trust. So the creator and the exchanger grantor are the 2 people who would do the first part of creating the trust. The exchanger grantor, who would be one of the persons who signs the certificate in the fidelity ceremony. Now, this is why this trust is specific, because it's actually done by having certificates and intacted by what you call a fidelity ceremony. And the exchanger grantor, so that's the person who would initially exchange or put their assets into a trust, holds the contracts and certificates, sovereignty included, which includes all the provisional law universally. And this is what makes a trust, its provisions. It's what it has and what it says it does. So the exchanger grantor creates the pure trust provisions, declaration of common law pure trust contract, and all its 6 parts. To emphasize, the exchanger grantor is the holder of the pure trust certificate and therefore the holder of the law. So by actually having the pure trust certificate and the pure trust contract creates, between the exchanger and the creator, actually forms the entity. Just that ceremony there by law. And then you would appoint a first trustee who would then receive the first asset from the former and conveys it to the trust, in which the trustee becomes the fiduciary. So a fiduciary is somebody who's in trust. They are the person who is trusted to manage the assets, manage the estate as per the provisions and as per your mandate or what you say in the minutes. So you can pretty much state anything you like in the trust minutes to say, okay, I want this to go to this person. I want this amount of money every month to go to here. And you can do this while you're alive and also for when you pass away as well. So once the first trustee gets the asset, he becomes a trust officer who then conveys, which means looks after the land and assets, to the pure trust. Then an agent and what we would call a managing director. So, and I want you guys to understand this trust structure is, I mean, I know some of you are just kind of getting familiar with trusts, and it is well, it's not a complex subject. It can be because you're working with different bodies of law, and you have different vehicles for different things, and this is a very different structure to what a lot of solicitors or attorneys and people like that would use, mainly because they use statutory trusts, and obviously that's because that's in their best interest to do that because of the fees and whatnot they can charge. But contractual trusts are real. Many people have upheld these sorts of trusts, and it's specifically how they are created, the documentation that comes with, and also the enactment of making sure that the trust is sealed and becomes law or becomes legal. So going on to the agent, this is the fourth person in the structure. So the agents may be elected by the Board of Trustees. Only trustees are appointed by the Board of Trustees. Sorry, only trustees are appointed by the board. So basically that's all they can do. Trustees can't really do much other than appoint new trustees. The agent privately, and again, this is why it's important to, why this structure is done this way for the privacy aspect, because the agents who are not written contractually in the provisions, but do make up the board of directors, known as agents, they are the true controllers of the trusts. And this is why these vehicles can be used, and people don't really know who owns what, because you have specific provisions that protect. So in this trust, the agents would not be disclosed, but it would legally allow you to have agents who could be yourself or anybody. And the real land and assets are controlled by the controllers. So once the elected provided by the trust provisions, now they have all the powers of the Board of Trustees. The Board of Trustees then become a prestigious position in the trust without any power whatsoever. This occurrence happens as a contract chattel written in the trust provisions. This occurrence happens as contract chattel written in the trust provisions. It must be understood that these elections, appointments, and ceremonies, etc., need not to be repeated as having done so already in the beginning by the Plagnet and Bauer on the 12th century. To emphasize and reiterate, all the power is now in the managing director privately and contractually written as the agent. So I'm just going to quickly go back to the structure so you guys can kind of see how legally this creates a vehicle, because let me just put this on quickly. Bear with me a second, guys. So yeah, so at the top here, you have the exchanger grantor. Give me a second, guys. I don't know if you can see my whiteboard on here. Okay, it's not coming on. Okay, it is. So you've got the exchanger grantor here, who would be yourself, let's say. And then you'd have your creator, who would be somebody from the First Republic Register, who would create your documents. So this person would be from the FFR, and then you would be over here as the exchange grantor. Oops. Yeah. And then your trustee would be somebody maybe in your family, a family member, a friend, or maybe not so much. Well, it could be anybody. It could be anybody that you trust. And then the agents could be, again, anybody who you would want to benefit from the property that you put into the trust here. And so this is the structure of this particular trust. So moving on, just going back to where we were. So yeah, so moving on to the benefits of common law pure trust. So it's a private object. It's the common law pure trust has a private lawful objective or purpose. So one thing that a lot of people do with trust is some of the trusts that are created are not lawful, or their purpose isn't for a lawful reason, and they don't stay intact, or they don't stand up. But these particular trusts have a private lawful objective that falls under common law and equity law and other laws as well. It has a suggested lifespan of 50 years, but is renewable, so you can renew the contracts after 50 years. It is a trust foundation framed by common law principia. It's a progenitor of all laws and contracts, both public and private, and all law is derived from the CLPT Foundation. Hence, common law pure trust foundations are creators and source of government and commercial societies. So basically, these trusts were what many of the monarchs and other royal and high net worth families use to create governments and other commercial societies. And that's some of the stuff that we don't get taught often, but this is how certain families or certain dynasties and stuff, they don't necessarily, or they're not subject to all the restrictions that the common man or the day-to-day person would be when it comes to taxation, when it comes to owning property, when it comes to governance. Okay, so some of the other benefits of a CLPT is the aspect of the Pure Trust Foundation is lawful and it's governed by the UCC, which is a Universal Commercial Code, which is contract law that oversees and supersedes pretty much all international laws when it comes to contract laws. So it's upheld globally and recognized by the International Courts of Justice and the International Criminal Courts. Because it has no reporting requirements, it reduces or eliminates accounting fees and foresaid taxes and probate. The common law pure trust can hold and operate lawful businesses anywhere in the world. So some organizations that maybe foundations or trusts or governing agencies, administration agencies would use a structure, something similar to this, especially private ones that we don't see in the public. There are a lot of groups and organizations that we don't know about, and they can operate business. Some banks and trusts are set up this way as well. But yeah, you can operate a lawful business anywhere in the world, and it provides limited liability protection and has the most advantage of a corporation, but none of the advantages. The benefits of a CLPT is it is a private lawful entity in the eyes of the law with the power to buy, own, hold, and sell property. So what I want people to understand about legal entities. So when you go to Companies House, you will sign a document and register that company, which then creates it as a legal entity. That's how you create a legal entity that becomes liable for taxation. You create a contract, you register your company, and therefore you will now have a tax liability to the organization you register it to. And that's how legal entities can be created. So a person can be a legal entity, a corporation can be a legal entity, an unregistered business organization can be a legal entity. There's so many different types, but a CLPT is a legal entity as well. So it can hold titles of landed property, but you can use and enjoy the benefits of the land and assets during your lifetime. So You control, but you don't own. The trust owns it between the contract that you formed during the fidelity ceremony. It is made irrecoverable to avoid any questions of ownership of the assets. So some recoverable trusts can be put back into the name of an individual. These trusts are irrecoverable to avoid question of ownership. Once it's in the trust therefore owns it. It renders assets virtually judgment proof, and it continues unaffected after your death as well. So how much does it cost to set up a common law pure trust? So it's done based on the net worth of assets that you'll be putting into the trust. So net worth assets of up to 1 million euros is 2,500 euros. Net worth above 1 million is 25,000 euros, and anyone with a net worth above 10 million euros is 250,000. So we're looking at a small fee of like 2.5% of your, up to 2.5% of your assets. So what does it include? So you would get your pure trust certificate, which is specifically printed on a certain type of paper. It's sealed, it's signed, it's stamped. You'll have the trust provisions, which I can't remember how many pages exactly, but it's quite a long list of provisions that cover all aspects of a trust, which makes it a trust that you can do pretty much anything with or assign anything into it. And any sort of mandates that you have, you would create that through minutes by having a meeting, suggesting what you want to do with the assets or the business or whatever you're holding in trust, and that would become enforceable by the trustee. You get your declaration of a common law pure trust contract, including the Antrustians addendum contract. You'll get the sovereignty certificate for exchanger grantor only. So when you create, part of this particular trust is you require sovereignty. You have to become a sovereign, or you need to be sovereign in order to create and have a allodial title or the full titles to your property. So you would get a sovereign certificate for the exchanger grantor who creates the trust, and then you would get some instruments, so pure trust instruments and templates, just in case you want to have your trust set up in a particular way. And then all the documents would be witnessed by the First Republic Register Foundation administrators, and all the certificates would be sealed by an International Court of Justice notary public. So that just makes your trust, doing all these things and having all these things just makes the trust certified. It upholds and adheres to every single step that needs to be taken to create one of these trusts that actually will stand up and uphold what it's intended to do. So how do you set up a common law pure trust? So the first step is arrange a consultation with the trust representative. You can do that. I mean, if anyone is interested and you're on the live call, just comment and leave your your email address, because we've got your name. Leave your email address in the comment box, and one of our representatives will reach out to you. So yeah, arrange a consultation so we can kind of find out what you're looking to do, what you have, and then you'd complete a trust administration form, which gets all the details of the trust name, the address, all the details that we'd need. Then you would appoint your first trustee and managing directors, and then you would hold your fidelity ceremonies to intact your trust. So that would just be doing the signature and getting everyone to sign, all your trustees and your managing directors, usually your family members. And then once that's done and complete, you get it signed and sealed, and then you would just file your trust documents, and that would be complete. So yeah, so guys, if any of this sounds of interest to you, and you're interested in a consultation, you want to find out more, you've got questions, you're interested but you're not really sure, or you are sure and you want to go ahead, you can book a consultation by dropping, as I said before, your name and an email address, and visit www.ffr.org or visit info@firstrepublicregister.org. Thank you, everybody.